Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about copyright violations. Cases that should have gone to the Supreme Court of Canada, but didn't. Ian Linklater had a problem with a company called Proctorio. Essentially what Proctorio does is facilitate exams for universities to make sure that there's no cheating, very much like the Turnitin service where exams and documents are checked to make sure that there's no plagiarism. Mr. Linklater created a fake course and then signed up for Proctorio to have Proctorio show him how the service worked and to engage the service for the fake course so that he could tell people how Proctorio was being used to adjudicate the truthfulness of the content and the authenticity and originality of the content that they were submitting to Proctorio. In doing so, he was given access to unlisted YouTube videos presented by Proctorio. They were not searchable or obtainable by the general public, but accessible and viewable if you had the specific link to the video. As a result, Mr. Linklater published the specific link to the unlisted videos on his website, essentially making this unlisted private content publicly available to anybody who visited his website, read the content, and clicked the link. Proctorio, in response, took the links down and sued Mr. Linklater, and Mr. Linklater countered again against Proctorio, saying that this was essentially a slap lawsuit, and that what he was doing was public protest against a system or a mechanism that he felt was not accurately or adequately doing its job, and that he had the right to inform the public about his concerns. The real question in this case arose because of whether or not publishing the links amounted to a copyright violation or whether this was considered the protected type of content about warning the public or commenting on matters of public interest for a public purpose. And the court disagreed with Mr. Linklater and dismissed his anti-slap claims, but ultimately Mr. Linklater appealed to the Supreme Court of Canada, who denied leave to appeal the case. And this case does raise very important issues. We've seen other cases in Canada that have dealt with the question of whether links constitute defamation, for example, and those cases were heard by the Supreme Court of Canada. Merely providing a link to copyright material that is published and made accessible from that link by another company doesn't in and of itself seem to create a copyright violation. It's not creating access to a resource, it's reproducing and publishing the resource as opposed to allowing people to access an existing resource that has already been published. And if copyright is going to be expanded in such a way, as it appears to be in the Proctorio case, then the Supreme Court of Canada should have the opportunity to comment on the ambits of that expansion of copyright protection to make sure that it is not having an incidental or incremental effect into legitimate ways of publishing links to copyright materials. The Supreme Court of Canada could have reined in what appears to be an outside creep or encroachment of copyright law into legitimate ways that protected works are being referenced in other circumstances. It is in some respects no different than a citation in a book or a hyperlink on a Wikipedia page. And yet the law as applied in this case would seem to suggest that this could potentially attract a copyright violation if those things are behind some sort of private or paywall accessible only by that link. This was an opportunity for the Supreme Court of Canada to get ahead of developments in copyright law that may have significant negative effects on the public sharing of information and may negatively impact the way that Canadians access information and distribute information amongst one another. Hopefully the Supreme Court of Canada takes the opportunity to hear something like this again and gives a ruling that limits outcreep of copyright law into areas that it was never intended to protect in the first place. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.